on the application of IAB, TTAN, or Child Violence Mitigation Grant, TTMB, INAN, and the Secretary of State for the Home Department.
Sir James.
Well, good morning. I am leading Mr. Holborn and Mr. Podjoy. The claimants are represented by Ms. Dubinsky, Mr. Knight, and Ms. Irving, and the intervener, Justice, is represented by Mr. Vassell-Adams and Ms. Mitchell. Timetable first, if I may. I'm going to make submissions in opening until roughly 20 to 1. So you'll have 20 minutes of Ms. Dubinsky before lunch and then a bit after. I think she's going to go for an hour and a half or a little bit over that. The intervener has been given permission to make oral submissions for 30 minutes by the court, so that's what he'll do, and then I will reply for roughly 30 minutes with a view to finishing at 4:15, assuming that's the time the court would ordinarily finish. So that's timetable. I wanted to say something about the current state of the proceedings. The case is due to be heard, the substantive case is due to be heard on the 7th and 8th of February. And our skeleton, as I understand it, or I'm not involved in the underlying proceedings, is due on Friday of this week. But we thought you ought at least to know, having received an email communication from, I think, one of the court staff or one of your clerks about the possibility of handing down immediate judgment, as it were, if that was necessary for the purpose of the proceedings. We've given you a copy of the order that was made by the learned judge below, which effectively and in summary see in particular the penultimate and upon in the preamble, and see paragraph 3 of the order itself. You'll have seen that in effect a holding pattern has been agreed and ordered so that the claimants' representatives, I hope that's a sensible course anyway, it's been done, yes. But the claimants' representatives and the court, of course, will receive the unredacted versions of these documents, and they won't be referred to pending, as it were. So there will be, no doubt, a need at some point, prior to the judge giving judgment on the claim, that the position will need to be clear, assuming, for the sake of argument, that he might want to refer to some of the names in question. Seems highly unlikely for reasons I'll come to, but that at least holds the position. So there isn't an immediate urgency, so that people can see things before a trial that is due to happen imminently.
That's it. That is very sensible, if I may say so. It may be that we're in a position to give you a result today, even if we don't give a reasoned judgment.
My lord, yes, but we thought you ought to see that at least, yes, so that you don't feel under pressure, as it were. Yes. That's a thing that you might feel.
Thank you very much.
Start delivering judgment or even a result. If you wanted to think about it further, there is the luxury of at least some time, yes, to do that. My lords, I hope you should have, I've got 2 physical bundles of authorities. They run, I'm afraid, to a rather large number of tabs. I think the last one I have is tab 47. But we'll all be referring and dipping in and out to those. I hope that's convenient, even though it is rather more authorities than you would ordinarily have. And you also should have a relatively short core bundle, in which there's very little that I'm going to need to go to, and a supplemental bundle, which I'm hoping should run to, the numbering is in the top right-hand corner of the page, should run to 366 pages. In the supplemental bundle, and again I'm not going to refer to very many of those because the issue before you is essentially an issue of principle.
Yes.
So I was going to, with that introduction, to pitch straight in, if I may, and to deal, I'm going to divide the submissions into 2, unsurprisingly. The first bit is going to deal, and the substantial bit is going to deal with irrelevance, and the second bit is going to deal with good reason for wanting to or wishing to withhold junior civil servants' names, which is what the deal is effectively about. As far as irrelevance is concerned, I'm going to group my submissions under 7 core submissions. The first of them is relatively short. It is that relevance is determined by reference to the grounds of challenge in a judicial review, including, and I'll come to this in a little bit more detail in the second submission, because of the duty of candour, including potential grounds of challenge. Those grounds, actual and potential, shape and dictate the issues in the case. And in that basic respect, judicial review and other civil proceedings are the same. There are pleadings in both, the purpose of which is to make clear for the court what the issues actually are. In judicial review, the claimant, as you're very well aware, advances a positive case as to the grounds on which unlawfulness in public law is said to arise, and the defendant responds to those grounds in a pleading, initially by summary grounds, which form the basis for the permission decision, and then by detailed grounds if permission is granted. And that basic process we submit in judicial review, just as in ordinary civil proceedings, is essential in order for there to be an orderly and clear identification of what it is that the court is being asked to determine. The process and the purpose of the process and the necessary discipline it brings is no different in a judicial review. And we submit, therefore, that the relevance of material, and I use that noun deliberately to cover both information and documentation, the relevance of material is judged by reference to the connection of it to the resolution of those issues. That's the first submission. The second submission is to acknowledge, of course, that the duty of candour is of considerable importance in judicial reviews, but it does not alter the fundamental way in which relevance is to be judged, in other words, by reference to the issues. Indeed, we submit that relevance as a concept, applying to the actual pleaded issues and the potential issues if that stage is still in process, as it were, relevance limits the duty of candour. Or put another way, there is no duty to disclose irrelevant material. The case law we submit on that submission, on that issue, is clear. The public authority, which is the defendant or the potential defendant if you're at the PAT stage, must disclose that information that may affect the court's determination of the challenge. In other words, information that is relevant to the issue or issues in dispute. We've given you lots of references in the skeleton to support that proposition, but just to pick out a couple of them, if I may, without needing perhaps to turn them up at this stage. The duty is to assist the court with, quote, and I'm quoting from Lord Justice laws in Quark Fishing in the Court of Appeal at paragraph 50, tab 9, page 321. The duty is to assist the court with, quote, a full and accurate explanation of all the facts relevant to the issue the court must decide. And obviously the single includes the plural. You get the same point from Lord Bingham in Tweed, for example, at paragraph 54, tab 12, page 408. The duty, as Lord Bingham put it, is to lay before the court all the relevant facts and reasoning underlying the decision under challenge. And the test for disclosure, in that case of documents, I'll come back to that in the context of judicial review, but as you put the test to disclosure at paragraph 58 in Tweed, page 409, the test is whether, quote from Lord Bingham, realistically their disclosure could affect the outcome of the proportionality challenge. We've given you in our skeleton argument for the purpose of the appeal both the reference to and the content of what Lord Scarman had to say in National Federation of Self-Employed and Small Businesses, paragraph 6.1 of the skeleton argument, upon general principles, discovery should be limited strictly to documents relevant to the issue which emerges from the affidavits, in the days when affidavits were the thing. Paragraph 6.1, the skeleton for Lord Scarman. Lady Hale from Bonku, can't remember which number, but one of the earlier Bonkus that went to the Supreme Court. Paragraph 192 of Lady Hale, tab 23, page 772, quote, a duty to make full and fair disclosure of, underlined, all the relevant material. Lord Justice Singh, in Horo, which was a later version of Bonku, again about the Chagos Islands, Lord Justice Singh in Horo at paragraph 20, tab 28, page 825, the function of the public authority is, as he put it, itself, and that's the proactive element of the duty of candour, is itself to draw the court's attention to, quote, relevant matters. Final authority in the sequence, PCSU, might just be worth turning that up very briefly. It's in tab 38 of the authorities bundle. A decision of Lord Justice Lewis and Mrs. Justice Heather Williams in April of last year, the year before last year, 2022. Tab 38. This was dealing, as you see from the first paragraph, with applications for specific disclosure in the context of an immigration policy to do with small votes. It rings a bell in terms of policy context being challenged. Paragraph 16. And if you want the introduction or the lead-in, it might be worth casting an eye for the basic principles on disclosure in JR. Might be worth casting an eye down paragraphs 12, 13 and 14, which we submit accurately summarise the position in relation to disclosure by reference to Tweed. And you will see, in particular, for present purposes, paragraph 16 on page 1154. Thus, the first question for the court is, and this is the first question in the context of public interest immunity, which is the title above 15, but it applies equally to disclosure because that's what it's describing. The first question for the court is whether disclosure of the material is necessary to resolve the matter fairly and justly. That is to be judged by reference to the issues raised by the parties' pleadings. The claimants accept that in the context of judicial review, the court may decline to order disclosure of part of a document where it does not meet this test. So,
could you just remind me, were the documents, the parts of the documents that were redacted there, did they exclude the names of civil servants? From recollection, it wasn't dealing with civil servants.
No, it wasn't dealing with civil servants. There are some cases in the bundle that do, notably in the information tribunal and the upper tribunal brackets information limb. There is also a case in a civil context that you will have seen called Shah, which doesn't deal with junior civil servants' names, but does deal with the names of employees within a bank which was being sued for delaying the execution of client instructions on the basis that they had made an authorised report to the police because they suspected money laundering. And there was a question about whether the names of employees were relevant for the purpose of the issues. You see the same approach. We may go to Shah in a minute. But my lord, I think is right. There was no particular question there. But I go to it for the general principle, which we submit is accurately set out at paragraph 16 of that authority. Just to amplify a couple of points flowing from those authorities. The first of them is that, as the passage I gave you from Lord Justice Singh in Horo makes clear, there is, of course, a difference in judicial reviews as compared to ordinary civil proceedings, precisely because the public authority has to be proactive. The duty imposed by the duty of candour is a positive one. It is to draw attention to material, as I've defined it, information and documents, to draw material to the courts and indeed the claimant's attention, so that arguable bases of unlawfulness are revealed whether or not at that stage raised or positively pleaded by a claimant. So the duty of candour applies, for example, at the beginning of the process when a set of correspondence triggers the potential for proceedings. But it's that duty, that positive element of the duty, which is the key feature of the duty of candour. And the key reason for that, in practical terms at least, is the obvious one, which is that the defendant will always have the material relating to the decision. But there is also, if one looks for broader constitutional principle underpinning the duty of candour, there is also, of course, the shared interest, shared as it were, between the court and government in enabling the court to perform its constitutional oversight functions through the mechanism of judicial review. And none of that, we would hope, is controversial. The point, however, is that recognising those key features of the duty of candour does not alter the yardstick. The yardstick remains one of relevance by reference to the actual or potential issues. Those issues simply include both any asserted or pleaded ground of unlawfulness and also any other arguable basis for contending the decision in question was unlawful, precisely because the defendant will have a monopoly on information. And so the duty of candour is the positive one, recognised by Lord Justice Singh. The duty is, quote, itself to draw the court's attention to relevant matters. That's what itself is referring to. It's referring to the public authority. That's the first expansion on that. The second one is that the duty of candour, again to explore its nature briefly, all of this I think is relatively obvious and uncontroversial, but better just go through it. The duty of candour is, as indicated, not just about disclosing documents. It is about both information and documents. And so, well-recognised, well-known features of the duty of candour, it applies from the off, as I've indicated already. It applies at the PAP stage, even before a formal pleading has been put in by a claimant. It applies throughout the proceedings. It is, in nature, a continuing duty. It applies to information. So it covers descriptions of the decision-making process or any other fact that may be relevant to the issues or to potential grounds for unlawfulness. It applies to descriptions given of the facts in correspondence, in pleadings, and in witness statements. And the essential substantive requirement is that all of those things have to be full and fair as descriptions. I'm told that live streaming, predictably, I've ever gone through a case with live streaming, which this submission is not made, I'm told that live streaming is not currently working. And there are people, no doubt, on both sides of the court who will be outside court who will wish to see it. I'm not sure quite what the court can or would wish to do about that, but...
Well, unless anybody wants to submit that we should pause while it's being sorted out, I think we should just press on.
Well, I'm very happy to just press on, even though there are certainly clients on my side who are keen to listen to the submissions, but I wonder whether some message could be got to the techno powers that be to see if they can't do something to sort it.
This has already sent an email.
An email has already been sent to the techno powers, whoever they may be. All right, Sir James, carry on.
Well, unless someone is going to tell me that there's a strong desire for me to stop whilst the techno powers do their thing, then I detect from the court that you'd rather I carried on. I think I would too. Would you just give me 1 second?
Yes, sir.
Forgive me for this. I'm assuming before I get too strident instructions, if I'm allowed to issue a message to the back of the court, that it will be possible for people to see a note of what I have said to the court in the meantime, so they can check that I haven't gone completely off the rails. Thank you. That seems to have borne fruit. So I'll carry on if I may. I've made the point that it applies from the off, it applies throughout the proceedings, and it applies to information and the descriptions of the facts that are given. It may also apply, and it's a may, to require the disclosure of documents or parts of documents. But it is important to note, and it's a point that's been very frequently made in judicial review cases, including in Tweed, and I'll give you the references in a second, important to note that the test for disclosure of documents, including parts of documents, is stricter than mere relevance. Disclosure is, as has been frequently acknowledged, not the norm and not automatic in judicial review. That is so even if a document is actually referred to in a witness statement. See Tweed, paragraph 38, tab 12, page 404 for that proposition. But the test generally that governs disclosure, whether there is a need to disclose documents, is the one that you saw cited by Lord Justice Lewis in PCSU from Lord Bingham and his famous passage in paragraph 3 of Tweed, page 390 of the same tab 12. Whether in the given case disclosure, as Lord Bingham put it, appears to be necessary in order to resolve the matter, by which it's plain that he meant the issues, fairly and justly. And as a starting point to that, and we submit it's not a bad basic starting point in the definition of relevance, the court asks, and it's the passage I cited to you earlier from paragraph 58 of Tweed, I think in the judgment of Lord Brown, actually, rather than Lord Bingham at that point, must be whether, quote, realistically their disclosure could affect the outcome of the particular challenge, whatever it may be, the proportionality challenge that was being made to the permission that had been given by the Parades Commission in Northern Ireland for there to be an orange march through Catholic territory, effectively, or Catholic streets in Belfast.
Well, in that case, as I recall, the chairman of the commission had made a statement or sworn an affidavit giving a summary of 5 documents, and the question was whether the claimants should be allowed to see the whole documents.
Yeah.
And in the end, after several appeals, it was sent back to a High Court judge to look at the documents and see what he thought.
My Lord, it was, for all the various purposes, may this be worth very briefly turning it up, paragraph 12, tab 12, it was sent back for all of the purposes identified by Lord Bingham in his speech, as you see in paragraph 5. So he sets the test in paragraph 3, which is the one I've referred you to. See in particular the final sentence of paragraph 3 on page 390.
Yeah.
Using the bundle numbering. And then the disposition of the case, my Lord correctly recollects at paragraph 5. See in particular, starting between A and B, the line beginning noble and learned friends, and for the reasons they give, I would order that. And then if you read to the end of the paragraph, so the relevance bit is really the bit between B and C. Do the documents add anything of value to the summaries? That was the bit my Lord was recollecting. But there was also an issue, as you recall, about whether or not they reflected information provided in confidence. But my Lord accurately recollects that, as one sees from paragraph 5. And I was right to recollect, I'm sorry if I misled you and gave you a reference to Lord Bingham at paragraph 58, it is of course Lord Brown. So before a document in judicial review or part of it becomes disclosable, the same test applying, as Lord Justice Lewis made clear in paragraph 16 of the PCSU judgment I took you to earlier, it must be both A, relevant to the issues, that's the minimum, and B, necessary in the Tweed sense for the document or part of the document to be disclosed. Again, none of that touches the basic proposition that the duty is, the basic duty of candour is limited by the concept of relevance, but there is the additional hurdle of necessary for the disposal, fair and just disposal of the issues, or the determination of the issues, that is added by Tweed. Just to pick up finally under this second submission, two contentions by the respondents at this point, so I get what we have to say in response to those. The respondents, as I understand it, contend that the concept of relevance is a shorthand which is apt to confuse here, and the question is rather what the applicable duty requires. And it will be evident from my submissions already that the attempt we submit to decouple the concept of relevance from the duty of candour is simply wrong in law and would mark a very significant shift in the very well-established principles that govern how the duty of candour actually operates, both in relation to information and more particularly in relation to the disclosure of documents. The skeleton of both the intervener and of the respondents seeks to redefine relevance for JR purposes and to adopt the statement in Quark Fishing, paragraph 50, that the authority must provide, quote, a true and comprehensive account of the way the relevant decisions in the case were arrived at, and then to adopt that true and comprehensive account as the mantra, in effect, throughout their respective submissions. But in doing so, they ignore what is required, and what is required is a true and comprehensive account of the way the relevant decisions in the case were arrived at. And indeed, they ignore the previous sentence in the judgment, where the court made clear that this description was required, and required, quote, the full and accurate explanations of all the facts underlined relevant to the issue. The court must decide. That's the passage I quoted you. So the court's intention, we submit, is clear in Quark Fishing. Relevance for the purposes of judicial review is not an open-ended category, but rather requires the authority to provide a full account of the decision under review for the purposes of the court's determination. If a fact does not, in truth, facilitate or is not connected with the resolution of those issues, it simply isn't relevant and isn't disclosable. And that is the message one gets from all the other plethora of authority that I cited to you, indicating that what truly mattered was relevance in the ordinary sense of the word, i.e. its a connection to a resolution of the issues in question. I wanted to take you to one other authority, perhaps at this point, just to indicate that there's nothing novel or particularly interesting about this, because if you go to the Shah case, which I referred you to, I can invite you to take that up. It's at tab 18 in the bundles of authorities. I'm not sure quite where your divide lies, but tab 18 might be in bundle 1.
1 to 21.
Yes, great. We've got the same. So bundle 1, tab 18. And I go here essentially to illustrate that the same proposition, as it applied to naming people, that you determine it by reference to the relevance that the names might or might not have to the determination of the issues, in a straightforward Queen's Bench action, now in the Court of Appeal, on appeal, you see the context of the claim from the first paragraph in the judgment of Lord Justice Lewison, which I hope I accurately described. And you'll see what the first instance judge, then Mr. Justice Coulson, what he did at paragraph 8, which by the time it got to the Court of Appeal looked like it was accepted by both sides not to be an ideal solution. Second sentence of paragraph 8 is he thought the employees should be identified by function, although not by name. Of course, the difficulty, as it appeared to be common ground by the time it got to the Court of Appeal with that, was that that would lead to their identification. So the mere reference to their function would lead to their identification, or could do so, no doubt by reference to other material. And you'll see the sequence of the analysis. You'll see what's been redacted, or what was redacted from paragraph 18, 1.8 on page 598. And you'll see the bank's position at paragraph 19. And you'll see the sequence of analysis and the sequence of questions that are asked by the court, and were asked, as it was common ground before the judge, in paragraph 20, starting at Roman 1, are the names of the employees relevant? And in truth, the real debate in this case, starting from that fundamental premise that what needed to be demonstrated was relevance, the fundamental debate in this case, on which there was some division between the members of the court, was as to precisely how you go about approaching that concept of relevance. There was no debate that relevance was the key. And you will see from paragraph 21 the citation or the description of relevance that Sir Thomas Bingham gave in Taylor and Anderson. See in particular the penultimate and final sentence of the quotation in paragraph 21. It is, I think, of no importance that a party is curious about the contents of a document, would like to know the contents of it, if he suffers no litigious disadvantage by not seeing it, and will gain no litigious advantage by seeing it. That, in my judgment, is the test. So he's there describing the concept of relevance, and the question then that the court considered was whether that was different once the CPR had been introduced in 31.6 in the manner set out in paragraph 24. And you'll see the well-known passage from Peruvian Guano, which was the test at the time of Taylor and Anderson in paragraph 22 before you get there. So that was the essential debate in the case.
Paragraph 25, Lord Justice Lewison does appear to say, although relevant is a use for shorthand, it's better to stick to the words of the rules, which is material which supports the case. There wasn't a case, or material which undermines it. Yeah,
my lord, that's true. And then the question was, between the members of the court, the real issue they were having to think about was whether or not Taylor and Anderson remained a good moniker. If I can put it that way, as you see from paragraph 53 in the short judgment of Lord Justice Mumby, in effect agreeing with Lord Justice Pill that although the rule had come in, Taylor and Anderson and that description remained just as good, although it had to be applied in the context of 31.6 rather than Peruvian Guano. So the majority of the Court of Appeal continued to, I mean, it doesn't matter for present purposes, but continued to consider that Sir Thomas Bingham's description of relevance continued to hold some weight and validity, even though Peruvian Guano test had been replaced by 31.6 in the way in which that was done.
Is this the only case in which the question of redaction of names has been considered?
I mentioned earlier an upper tribunal case considering an earlier FTT case.
Yes.
And there is also, you will have seen from the bundle, a decision or two decisions, which I'll come to, from Mrs. Justice O'Farrell in a procurement context, where, as usual in procurement cases, the thing was brought as a procurement challenge under the relevant regulations, but also, perhaps importantly, as a judicial review. Often those cases you put it in either or both of those.
I should have asked a different question, which is whether it's the only case at appellate level in which redaction of names has been considered.
Yes. certainly the first case at your level. And
This almost has the flavour of an informant case about it. I mean, the claimants wanted to know who in the defendant organisation was involved in shopping them to the authorities,
yeah,
and suggestions of money.
they did. And the question that the court grapples with, see in particular paragraphs 36 and 37, was whether or not the names, which is why I go to it as an example, was whether or not the names were actually relevant in the sense of assisting the court to determine the issues that actually remained. Now, what they did, of course, was to apply Peruvian Guano or Sir Thomas Bingham or 31.6 or all three together, as it were, but they applied it to that issue.
The issue was whether the defendants had a suspicion or a reasonable suspicion.
Yes. They were put to proof as its genuine suspicion was what remained, as you see from paragraph 37. So all I'm going, I should make it clear, it's complicated because it's dealing with a different set of issues, which is the difference between Peruvian Guano, Sir Thomas Bingham and 31.6, essentially. That was the issue of principle on which the court had slightly different views, with the majority continuing to believe that Sir Thomas Bingham's description of relevance continued to have some weight. But the significance of this case for present purposes, apart from the fact that it deals with names, is that this is just a straightforward example of someone judging whether or not the name should be disclosed by reference to relevance, which, however you define it, is essentially working out whether or not the names will in fact assist the court to resolve the actual issues that face the court. That's the only reason I go to it, to illustrate an absolutely standard approach. So you see the court tracing it through. Whatever the actual test for relevance in that civil context, relevance governs whether or not names could be redacted from the documents. That's the first of the respondents' contentions I wanted to respond to under the heading, under this second submission, dealing with the duty of candour and so on. They also contend that what they describe as a direct relevance, whatever that may mean, a direct relevance test does not, as they put it, befit the public interest exercise that underpins judicial review. And my submission in response to that contention is that the public interest underpinning judicial review is perfectly satisfied by the duty of candour containing the particular features that I outlined earlier. In particular, its proactive nature and the requirement that it brings to provide full, fair and accurate information. Cards face up on the table is all about that, so that the court, from the party who is likely to have the monopoly of information, gets a full, fair and accurate description of what's going on, or what did go on. But that public interest, or that set of public interests underpinning judicial review, or more accurately the feature of judicial review that is the duty of candour, can perfectly well be met by limiting, as is entirely ordinary, and as all of the case law I've taken you to already at the highest level indicates, by limiting the provision of both information and documents to those which are relevant, in other words, which will assist the court to actually determine the issues. And we note that one of the features of judicial review is to impose, if anything, a higher test on the disclosure of documents than would apply in ordinary civil litigation, because the test that needs to be applied in a JR where disclosure is not automatic, no doubt in part because the full, fair and accurate description of the information is required to be given under the duty of candour, but the test for disclosure of documents, including parts of documents, is that set out by Lord Bingham in paragraph 3. So necessary for the fair and just disposal of the issues in the case. And indeed, it is one of the features of judicial review and of the way in which the duty of candour works in practice that the court has recognised that in judicial review it is not permissible for the public authority to do what it might do if it was to take the phrase from my learned friend's skeleton argument, a hard-fought piece of commercial litigation, which is simply to produce wagon loads of documents and hand them over to the claimant. That is not acceptable in a judicial review. There has to be a selection. That, or authority for that, if you wanted it, it is Lord Justice Singh again in Horrow, paragraphs 19 to 20, tab 28, page 824, where, as he put it, the authority must not, quote, overwhelm the claimant's representatives and obfuscate what the true issues are, or, as he put it, simply offload a huge amount of documentation on the claimant and ask it, as it were, to find the needle in the haystack. Rather, again to quote from Lord Justice Singh, it is the function of the public authority itself to draw the court's attention to relevant matters.
Well, they're not supposed to do that in ordinary civil litigation either.
My lord, no, but what you have to do is to produce everything which might satisfy the 31.6 test of relevance. Of course, that isn't, I overstate it, but you get the point. Yep. There's a particular duty of selection, is perhaps the lesser and more accurate way of putting it in judicial review. That's the second submission. The third submission is that there is also a common principle across judicial reviews and other civil proceedings, which is that irrelevant material can be redacted from a document, otherwise itself properly falling within the obligation to disclose. So a document can have relevant information in its content, and if it also has irrelevant content, that irrelevant content can be redacted. And the threshold test is the same whether you are considering the provision of information under the duty of candour or the content of a document. Is it relevant? If it is not relevant, as Lord Brown put it in Tweed, could it realistically affect the outcome of the challenge, then the content or parts of the document can be redacted. And as I've already submitted, relevance is also to be judged, therefore, by reference to the particular piece of information under consideration. In other words, the particular passage or passages of the document that actually bears on the issues and those which don't. Lord Justice Hoffman, as he then was, considered this issue in the context of ordinary civil litigation. In the GE Capital case, if I can invite you briefly to go to GE Capital, which is behind tab 7 in bundle 1. You see the head note on page 281. And one of the parties, you see, was claiming that all of the document had to be produced because some part of it was relevant. And ultimately, the narrow issue, which was directly before the court, was what was the nature of the test that the party claiming to see the additional bits of the document had to surmount. How strict was it? That was ultimately what was an issue. But C, for present purposes, 283, using the bundle numbering, 283 between the letters B and C, where Lord Justice Hoffman says, almost directly between B and C, it has long been the practice that a party is entitled to seal up or cover parts of a document which he claims to be irrelevant, and then he cites from Bray's Digest of the Law of Discovery in the passage that you see.
Can we just check the facts as to what the parts were, looking at bundle page 282?
It's 282 flowing over into 283. Yeah.
It wasn't the names of people involved in the transactions that were party to this.
No.
It was other financial transactions.
It was other transactions.
Yeah.
It was. Exactly so. I'm sorry, I should have made that clear. It was. There's no straight parallel on the facts with us. And there was a debate around whether or not it was or might be thought to be relevant that the particular party was involved in that other transaction. As I said, I hope fairly, the central issue of principle before the court was what was the nature of the thing that had to be shown by the party seeking to open up the document. And Lord Justice Hoffman presages that issue between D and D on page 283, that little paragraph beginning the oath of the party. So a pretty strict test. Perhaps the key reason for going to this case is to be found over on the next page at 284. For the basic proposition from Lord Justice Hoffman between G and H on page 284, picking it up in the line beginning, it can be reconciled. The next sentence, in my view, the test is whether on discovery part of a document can be withheld on grounds of irrelevance, is simply whether that part is irrelevant. The test for whether part can be withheld on grounds of privilege is simply whether that part is privileged. There is no additional requirement that the part must deal with an entirely different subject matter from the rest. Peruvian ground has got to be applied to the information contained in the covered up part of the document, regardless of its physical or grammatical relationship to the rest. Just to pick up this point, so I don't have to go back to the authority, relevant and irrelevant information may, as in this case, be contained in the same sentence, provided that the irrelevant part can be covered without destroying, this is the test, without destroying the sense of the rest or making it misleading, a party is permitted to do so. And that is essentially the approach that was followed by all members of the court. To take by way of example, Lord Justice Leggett, Father Lord Justice Leggett, given the date of the judgment. Lord Justice Leggett, second sentence, plaintiffs are obliged to disclose the relevant parts of documents, but not the irrelevant. Skip a sentence, for over a century, litigants have been permitted to cover up or blank out irrelevant parts of documents. So it's clear, we respectfully submit, that in both civil proceedings, and there's no earthly reason why a different position should apply in judicial review, it's clear that a document can be redacted on grounds of irrelevance, that is, no relationship to the issues the court is actually going to have to determine for the reasons I've already submitted, in both civil proceedings and in judicial review. And there's no reason why the principled approach set out by the Court of Appeal in GE Capital should not be applied. That is entirely unsurprising, we submit. There is no obligation in judicial review, and none is triggered by the duty of candour, to provide information, still less perhaps to disclose parts of documents that are not needed to enable the court to determine the issues, namely whether or not the public authority has acted unlawfully on any of the grounds that either are asserted or at the earlier stage could reasonably be asserted. So the approach to redaction is based on whether or not we submit the parts of the document that are redacted are relevant to the issues that the court has to decide. That was the test that was applied by Mrs. Justice O'Farrell in the Good Law Project case. Can I invite you to take that up? If you put bundle 1 away and take up bundle 2 and go to tab 33, if you would, please. The page I want is 942. Better start a bit earlier, perhaps. So the beginning of the judgment is 936. It's tab 33. You'll see the nature of the application that she was dealing with in this effectively interlocutory judgment from paragraph 1. And this was, as I've said earlier, a procurement claim and a judicial review. Those things are to be separated, but it certainly was a judicial review as well. And Mrs. Justice O'Farrell starts with...
But in paragraph 4, the defendant was prepared to disclose to the parties the names in a confidentiality ring, but not to disclose them with the possibility that if they were read out in court.
That was the solution.
Okay.
But that was done as a matter of not of obligation, because they had the argument about whether or not they needed to be disclosed more broadly. But that was indeed the solution. So they effectively took the pragmatic solution you saw from the order at the beginning of this hearing and applied it through the proceedings into a confidentiality ring. But the argument of principle was nevertheless had. She starts, as you see at paragraph 9, with a long citation. And again, we submit entirely accurate and entirely consistent. Indeed, part of this was the passage I cited to you from Lord Justice Singh in Horo, Salange Horo, and Bonku, 2018, and we respectfully recommend those well-known passages dealing with how disclosure works, citing Lord Bingham in Tweed, as you see in paragraph 11, from the quote on page 938. And then describing what the duty of candour and cooperation is in the remainder of that quote. So that was her starting point. Go on in the judgment then to the principled approach and what happened. Paragraph 23, the starting point for the court is always the important principle of open justice.
Just past paragraph 13 again. That's quotation from guidance. Is that guidance still in force? Do not withhold altogether where you can redact. Do not redact where you can disclose.
I'm not sure whether that version is, but we've definitely got a version of GLD guidance in the bundles. But can I check with the up-to-date version? You've certainly got one in the bundles. I'm not sure whether it's precisely reflected in that.
Yes, please.
But yes.
The wording looks familiar. The wording looks familiar,
yes.
So it's going to be approximately the same.
Yes, I think it is. I don't think there's any reason why it should have changed particularly. Then paragraph 23, the starting for the point for the starting point for the court. You see that? Then there have always been exceptions, she says in paragraph 24. Get from paragraph 24 also that it's a claim that's made by way of judicial review, so you're dealing with JR. She then cites, she deals with confidentiality rings in 26, but she then cites Shah, which we've seen, at paragraph 28. puts it, summarising Shah, the first relevant question, I'm reading from 28, second sentence, the first relevant question is whether the redacted information is relevant in the sense that it supports the claimant's case or adversely affects that of the defendants. The starting point for the court is to consider whether the names of the individuals in respect of whom it's sought to put into the public domain are relevant to the issues that the court has to decide. The identity of the party to the document has no relevance to the issues, then there is no obligation on the defendant to make those names public.
It seems in paragraph 28 to be saying, isn't she, it's agreed that the documents can be disclosed into a confidentiality ring. What I have to consider is whether they should be disclosed unconditionally.
That was the issue that was before her.
Yes.
But she considers the relevance question as a point of principle. When she comes to the second judgment, you'll see she revisits the issue as to whether or not the name should be disclosed after having had the trial. But we respectfully submit that that citation of Shah is accurate, and the principle that she derives from it, particularly in the last two paragraphs of paragraph 28, is also accurate. Can I invite you then to read paragraph 30, 31 and 32, dealing with senior versus junior members of staff and so on.
She's talking there about senior versus junior, as you say, but is there any indication that she is applying the same criterion for what counts as senior or junior as you seek to apply in this case?
My Lord, I'm not entirely sure that that comes out from the judgment, but I'm pretty sure that that case did draw the distinction between junior civil servants and SCS, senior civil servants. So I'd be very, very surprised if the distinction was in any way different there. I mean, whether it was quite as sharp, I'm not sure. It doesn't appear from the judgment, and we can no doubt take steps to check. But
Okay, thank you.
it was essentially that, I think. But as my Lord Justice Bean rightly points out, there was a confidentiality ring agreed there, no doubt on a pragmatic basis, and in they went. And you'll see then, just to trace this bit of litigation through, you'll see then that she then produces, after the trial, a very long and detailed judgment.
So before we do this, it's an odd way round of doing it. It's what they tried to do in the PCSU case. The parties agreed they'd have a confidentiality ring, and the court said, no, we're not going to support that as a blanket principle. You've got to go through the hoops. Yeah. And at 36 and 37, it seems to their own start with confidentiality, what the parties are prepared to live with, and then the individuals can make challenges as they see fit with regard to specific individuals and or categories of individuals.
Yeah.
So, did you actually decide anything?
Well,
other than to say, I'll start with confidentiality and see where we can see where it goes?
No, she doesn't formally decide anything at this point for precisely that reason. She explores the nature of the principles, and my Lord, I have some, I may respectfully say so, some considerable sympathy with the idea that it's slightly cart before the horse, because the solution to the issue of principle that confronts this court is not in all cases to do the pragmatic thing, if that's what it really is, and to do a confidentiality order and then come back at it later. You can no doubt keep matters under review, and there may have been particular reasons I know not in that case for doing it in that particular context, and there certainly were particular reasons for agreeing the order that you saw at the beginning of this hearing here, because that was in effect made a...
Well, that's slightly different.
It was made a condition of the stay by the learned judge, otherwise it would have been full-blown open disclosure preempting the outcome of the appeal to this court, which would have been slightly problematic. But I do respectfully share my Lord's concerns that that isn't the right way of doing this. We're here to argue the principle of relevance, effectively. And if, unless there is good reason for concluding that particular junior civil service names or other names are relevant, then there shouldn't be a confidentiality ring at all. In any event, she did consider the general principles. It is a case to do with junior civil servants' names, query, however defined, picking up the point my Lord Justice Mayall's put to me and the uncertainty about that, but I think the position is it was a similar at least divide. And she does consider the authorities, so I respectfully submit it is at least helpful. No one's suggesting it's binding. Wouldn't be binding whatever she decided because you're the superior court, but I thought it was at least appropriate to draw it to your attention for her consideration of the issues and her conclusion in particular about junior members of staff at paragraph 32, which we respectfully submit is correct, at least as far as it goes. And then when she'd had the trial, and there'd been the confidentiality ring, and everyone had looked at all this, and the issues were then worked through and determined, she comes back at this issue in tab 36. If you go, if you would, to paragraph 264 on page 1036. And it may be that part of the temptation to go into a confidentiality ring in that case was because one of the bases for a confidentiality ring was already made out, because there was commercially sensitive information. Does my lord see that from paragraph 264 on page 1036? And confidentiality rings are obviously sensible for that purpose, so everyone no doubt thought, well, if we're going to go into a confidentiality ring for that purpose, maybe park the issue of civil service names and come back at this. But you see that from 264 on page 1036, if I can invite you to read that. And as you'll see from two lines below the letter F, likewise no attempt has been made to explain the relevance of the names of the individuals currently redacted. Final sentence, if the information is not relevant to the issues the court must determine, again, correct approach we submit, there are no, in a judicial review, there are no grounds on which it should be admitted as part of the evidence in the hearing.
Well, it sounds as though that wasn't an issue either, that she wasn't being asked to decide whether the names should be made public.
Well, my lord, no, because no one had suggested
that the names were relevant.
Exactly.
Right.
And relevant by reference to the issues in the proceedings.
Yes.
Which is the correct approach we submit. That in fact is what happened. So having gone into the confidentiality ring, having as it were parked the issue with a provisional view that you saw in paragraph 32, knowing that the confidentiality ring was coming for whatever reason, maybe in part because it was commercially sensitive, in fact no attempt was made to suggest that the names would actually assist or did actually or had actually assisted the court to determine the issues. And in those circumstances, my lord is right, technically she didn't have to decide it, but she states the issue of principle correctly in the final sentence of 264 is my submission. And she also states the consequence of that correctly in my submission in paragraph 266. Including in the final sentence, it follows that the principle of open justice is not engaged in relation to the redacted material.
What was she actually dealing with in deciding these paragraphs?
She, as I understand it, she was determining whether any material which had been considered in the confidentiality ring, including the commercially sensitive material, should form part of the court's or the evidential basis for the claim, as it were, so as to justify on relevance grounds their being part of the record and no doubt referred to as part of the judgment as appropriate. So she's tidying up the issues from the confidentiality ring in the ordinary way. She also concludes, on the basis of the evidence before her, as you see in paragraph 268 for good measure, see the final sentence of paragraph 268.
Yes.
So the third submission is that irrelevant material can be redacted from documents. Relevance is the test, relationship to the issue. That's how the court has treated it, both in civil proceedings and in judicial review proceedings, as you have seen. And I had just one additional feature before coming to a couple of points by way of response to the respondents' submissions. One additional feature by reference to the duty of candour. As we know already, the duty of candour applies to both information and documents. But it extends for present purposes, for the purposes of this point, to information. And if the position really is that it requires retention or disclosure of the names of junior civil servants simply because they were involved in some part of the decision-making process, whether being named in email chains or passing on submissions to secretaries of state or whatever it may be, then the question is prompted, why, on the logic of the duty of candour, does the same not apply to the information part of the duty of candour? Why does one not have to summarise or set out the names of all of those involved, including junior civil servants? And that, we respectfully submit, would be a pretty odd consequence. Anyway, that's a small point. To respond to a couple of the points that my learned friends make, they contend that a document disclosed under the duty of candour must be disclosed in full, subject only to PII, public interest immunity, LPP, or statutory bars or restrictions imposed by Parliament. We respectfully submit that that demonstrates the extremity.
Is that what they say? I don't think it's at all.
Well, my lord, it's their skeleton at paragraph 26.
Right, let's have a look.
James, what's the flag paragraph? 27. And 22 and 27.
I hope you heard the whisper.
Yeah,
22
22
and 27.
yeah.
Yes, 2 and 27.
Yes, I thought, for example, to light on something uncontentious, I don't think anybody is contending that, for example, phone numbers or room numbers or email addresses should have to be disclosed.
My lord, they aren't, but it is worth at least pausing at that point,
Yeah.
because the question is why? And why is no one contending that? Why was the judge contend with that? And the answer is because they're irrelevant.
Well, you say that everything in a document which is not, which will not arguably affect the result of the court's case can be redacted.
Which will not assist the court in determining the issues, is the way I put it, i.e. the traditional approach to relevance.
So all names, except ministers, can be redacted in every document, unless there's an allegation of bias or something like that.
Or there is a question, for example, as to whether or not the seniority of the person was at the requisite level, which may arise in determining rationality issues under Carltona, for example.
Yeah. Okay.
But my lord, that is how we put it, as a matter of practice, as you know, and no doubt because there aren't concerns and sensitivities about the senior civil service. In practice, that is not done in relation to senior civil servants, even though technically it could be. That isn't an issue of principle, but the position we submit is that the relevance issues would apply equally to both. The question is relevance, that's the test. I don't want to ascribe an over-extreme position to my learned friends, but as we understand the purport of their submission, the core of it is that actually it isn't to be determined in that way. There's something broader than that, broader than relevance, as I have described and defined it, and we respectfully submit shortly. That is wrong for all the reasons that I've given.
I thought they were saying, if you choose to disclose, if you choose to fulfil your duty of candour by providing documents, then unless there's a good reason for redacting bits of the document that relate to the issue in question, you should disclose that bit. If there is a good reason, or if it doesn't relate to the matter in issue, you don't have to.
Well, I'm sure that's the way they would choose to put it if they wanted to. But the answer to that is that it's no good saying good reason. The test is relevance. What we're after is what is the moniker? What is the actual test? And I've taken you to reams of authority that make it absolutely clear that the test is relevant in the sense that I've identified it. And indeed, not merely that, but that's the test that applies to the disclosure of parts of documents because you can redact them. And you've seen the myriad authorities on that front, both in the ordinary civil proceedings context and in the JR context. What they really seek to do is to say, as the judge did, you've got a slightly different approach to that when you're dealing with JR because JR has the duty of candour. And I can come to that directly, if I may, in my later submissions. All
right. Should we go on to point 4?
Oh, yes. Submission 4 is that there is no principle unique to judicial review or inherent in the duty of candour that redaction is only permissible where the information redacted, quote, does not concern the decision under challenge. And I take those words from the judgment of Mr. Justice Swift at paragraph 22. He says it's only permissible, quote, where the information redacted does not concern the decision under challenge. And my submission, with great respect to the judge, is that that is simply an invented redefinition of relevance. It has no justification whatever, in principle or in authority. So far as authority is concerned, the authority is clear. It indicates that the yardstick for provision of information in judicial review is relevance, defined in the usual way by reference to the connection to the court's determination of the issues. All of the authority I've already shown you is clear on that. There is no authority whatever to support this much looser test, does not concern the decision. And the position is a fortiori, we submit, when it is acknowledged that the test for disclosure of documents in judicial review, under the duty of candour, is relevance plus. In other words, relevance plus necessary for the fair and just disposal of the issues in the case. See Lord Bingham in Tweed. So that's authority. In principle, the first point to note is that this invention, I don't wish to be rude to the learned judge, but this invention is only necessary because relevance, defined by reference to the actual issues to be determined, is absent. Or to put it another way, by that well-established yardstick, the information or content in question is irrelevant. We submit that there is no basis in principle for the imposition of that looser test. And a couple of sub-points onto that, if I may. One, it is not necessary to impose that looser test in order to ensure the fair determination of the issues. The information or content as irrelevant forms no part of and will not assist in that process. Secondly, it is far too broad a test, we submit. It would appear to mean, perhaps it's designed to mean, that anything in the document that could be positively excluded, that could not, be positively excluded from connection to the decision falls outside the scope of permissible redaction. But that divorces it from relevance, and it divorces it still further from the test of disclosure in Tweed. Thirdly, we submit that the three reasons provided by the judge for that looser test are unsound. The first is the one that he put in paragraph 20 of his judgment, as he put it, that, quote, hiding detail that aids the court's understanding of the public authority's explanation of the decision under challenge is antithetical to the purpose of the candour obligation. No doubt. If that was really what was being done, the point would have force. But it isn't. That's simply an inaccurate and contentious hiding way of describing redaction of material that is irrelevant. And then perhaps more significantly, under this first justification for the looser test, at judgment paragraph 19, ensuring, as he puts it, that documents disclosed to explain a decision-making process are readily, underlined, intelligible, is an objective worth achieving for its own sake. The first answer we give to that intelligibility suggestion is that that is not the test. And I've been through and went through Lord Justice.
Sorry, Sir James, can we be clear? Are you saying that the judge is wrong in that sentence?
I'm saying he's wrong in principle.
Wrong in principle.
Wrong in principle.
Yeah.
And he's wrong in principle because the test is relevance. That is the connection to the issues for all the reasons I've given. And he's wrong on authority because there's no reason to apply a different approach in judicial review to that which applies in ordinary civil litigation for this purpose. And the test that Lord Hoffman set out in GE Capital, as you will recall, was that, quote, provided that the irrelevant part can be covered without destroying the sense of the rest or making it misleading, then the irrelevant part can be redacted. And in relation to the names of junior civil servants, where they're not relevant to an issue in the proceedings, that proviso is by definition satisfied. The name does not touch the content of what is said at all, so it can't destroy the sense of the document or make it misleading. And the logic of Lord Justice Hoffman is not inherently at fault, as the judge appears to have thought at paragraph 16. We dealt with that point in our skeleton at paragraph 33. I don't take up time on it. But there is no reason, we submit, for the position on this aspect, this test, to be any different, just because it is a judicial review. That's the first answer we give to this. The second is that in any event, the fact that a junior civil servant called Smith was copied into an email chain or provided a ministerial submission under cover of an email cannot, on any view, we submit, be said to aid the understanding of the explanation for the decision. The explanation for the decision is in the reasons for it, or, if there is a procedural challenge, whether the facts bear that procedural challenge out. And the name Smith, the fact that the civil servant happened to be called Smith, is in neither camp. There's no deficit in reading documents, particularly where it will be evident in any event, or can be made evident in any event, which department or unit people come from. I just touch on those matters and the possibility of providing further information in any event if necessary. I emphasise in doing so that it will not be necessary in every case, but it can be done if there is good reason for doing so. So ciphering could be done, or can be done if there is good reason for doing so. Perhaps if it was really necessary for the purpose of the issues to see whether...
Who would decide?
Well, my lord, in the first instance, my submission is that there would not be a need simply to go straight to ciphering. And if the claimant wished to say, well, it's important for me to understand, for example, whether the sender of email 1 was also the recipient of email 2, then they can make that case in correspondence and the court will rule on it if they need to. But the point for present purposes is that ciphering is a possibility if there is good reason for doing so. Because what you need to do, and what it is appropriate to do to test the principle, is to isolate what it is that you're actually arguing about. And here what we're arguing about is the actual name of the junior civil servant. And again, you can include, if necessary, the unit or the department. I'll come to some documents in a second, but you can do that by reference to perhaps what remains of an email address, .gov.uk or .levellingup.uk, .homeoffice.uk. you can see which department it was. But if there is, for example, a particular reason why you need to know whether it was a person from a particular unit within the department, and that isn't evident from what remains in the document, then again, although that doesn't have to be done in every case, and the judge was right, we respectfully submit, to acknowledge that these sorts of solutions would be, as he put it in paragraph 19, laborious. The punchline of that is that is not that to support the position that there is an obligation not to redact irrelevant names. The true punchline of that point is to emphasise that we are not suggesting that it should be done or needs to be done unless there is good reason for doing so, a matter on which the court is perfectly capable of ruling. But what these points illustrate is the need, we submit, to be tightly focused on what is actually being argued about. We're not arguing about content, we're not arguing about departmental provenance, ultimately. We are not arguing about who runs of documents might have come to or from, because if there is good reason, they can all be dealt with by ciphering, which is unobjectionable. We're simply and only arguing about the name Smith, the names of the junior civil servants. So to go to the, to take just a couple of examples, if you go to the supplemental bundle and you turn up page 223, and I hope this is a genuinely kind of random example, this isn't a selected example. Page numbering on the top of the pages, if you would, gets a bit confusing. So 223 on the top right-hand corner. Just to be clear, Robert Andrews is the name of my instructing solicitor, so there's no great significance attached to his name at the top of the document. It just means that he printed off the disclosable email chain, as it were.
Oh, I see.
But you see the way in which it's been done. That first email just has names and doesn't have other email addresses. So, as I understand, the junior civil servants' names alone have come out, senior civil servants, and obviously the Secretary of State has been left in, or private secretary to the Secretary of State. And then you will see the way in which it's done. If you look at the next email below that, halfway through page 223, you will see that in a large number of cases at least, you've got the remaining bits of an email address. You can tell which department an email comes from, and so on. But what that example illustrates is that the documents themselves, that email chain, plainly remain intelligible. It is only the junior civil servants' names that have been redacted. The names of the senior civil servants remain. Even on the judge's approach, there would still be a large number of redactions if there's a kind of visceral reaction against blacklining in documents, because he accepted that the contact details, addresses, telephone numbers and so on could come out, presumably on the basis of relevance. And of course, as I indicated, if there is a genuine need to understand, for the purpose of assisting the court, whether or not a particular person sent the first email and was the recipient of the second one, whether they were the same person, then a case for that can be made and an explanation can be given if there is good reason for doing that. So we're not...
Sounds like a recipe for a great deal of interlocutory work in the administrative court.
Well, my lord, I don't respectfully agree with that. Of course, it will or may lead to some work, but a claimant will need to make a case. They will need to say, well, it's quite important that I should understand and know whether that particular email was sent by the same person who sent the other one.
There's no point going through it page by page, but I just happened, you said at random, so I opened another page at random just to test the JCDC, and I looked at page 325, and at the top there's something from Kathy Page, who she ed, and then it's a list of topics that are relevant to this topic, and then at the end it says, it's a good idea if we work up our own views, I don't know who they are, and a group of us can come to discuss this tomorrow. So when I go through the rest of the emails, because I don't know who those are, if I see material later or earlier on in the chain saying what the view is on items 1 to 7, it's not going to be easy for me to know if it's those people whose views aren't necessary, or whether they're the views of people that aren't necessary. It just gets jolly difficult, doesn't it?
Well, it isn't just Kathy Page, with respect, my lord, because the email starts
Oh, that's
It's
the previous page.
from
the
the
previous
previous
page.
page.
So it's from the private secretary to Michael Gove to a number of civil servants in, it appears, levelling up. And we know that the senior civil servants are not taken out and the junior civil servants are. And there's no redaction from any of the content of that email. The only thing that has been redacted that is of relevance to this debate are the names of the junior civil servants. The document remains entirely intelligible. The only thing
it's not that document, it's other documents then. If they come from people in the blacked out bit, say there are other things that come from people in the blacked out. Well, say there are other documents that tell us views on 1 to 7, and we don't know if they're not ones of the ones listed on 324. How is somebody going to know whether it's one of the lower people who's been delegated to work out a view on 1 to 7, which isn't central because it's not their views, it's Home Office views? It's going to be very hard to work out or to be sure, isn't it?
Well, the only thing that's been redacted are the names on the email, the junior civil servants' names on the email chain. It doesn't tell you who considered any particular issue.
No, it's not this email. I understand what that email says. It says we've got 7 topics. It doesn't matter what we think. It's what the Home Office thinks. But we ought to have our views. I understand that.
Yeah.
But what I'm saying is if I'm reading a whole set of other emails, and I've got lots of other emails which have views on 1 to 7, how do I know if it's the Home Office or if it's one of the blacked out people in this email whose views might be interesting but aren't relevant? Doesn't it make it difficult, is all I'm saying, to understand the process by which the views of the decision maker, as compared with the views of other people, is being reached?
My lord, my respectful submission is that, of course, the names are blanked out. So if one wants to say, well, the names are blanked out, so it's difficult. Of course, that is so. But all that is actually blanked out is are for present purposes the actual names. If there was a particular reason for wanting to know whether or not that email chain or some other email chain was considered by the same person or the same group of people, if there was a particular reason by reference to the issues for that being remotely interesting, then the question can be asked, and if necessary, ciphers can be put and departments and units can be put if necessary. No one's ever suggested there's anything remotely interesting in that in this case.
But say the question that's put is whether or not there is a Tameside duty of inquiry made, and you take us to an email which hasn't got the names on, which shows that point 1 to 7 were considered. But if in fact it's not considered by the decision makers, being considered by one of the blanked out names in this group, we wouldn't be able to piece together. I mean, it's just an example. I don't think you need to take time over it. It's just an example where something might be generated by people whose names we don't know and might appear later in the email chain.
My
You just can't read
Yeah,
back.
of course, and I don't wish to trivialise the issues, but the answer of principle is, if there is a reason, based on the issues, based on relevance therefore, for needing to know matters like that, whether or not a particular name did or didn't feature in the email, it may not give you the answer to that question anyway on the basis of these redactions, whether they're opened up or they're not. But if the answer to it does lie in the blacked out bits, or that might be relevant, then all one has to do is to ask and make that case, and a judge can rule on that as necessary. That's not going to mean that the admin court is going to be swamped with applications in every case. What will have to be done is that someone will have to say there's a jolly good reason for wanting to know why or whether that person was the recipient of the earlier email. So I don't exclude the possibility. I'm not arguing with my lord in principle. Of course, it may be important to know what went on in certain ways, depending on the nature of the challenge. But my submission is that if there is good reason for doing that, you're never going to need to know that it was a person called Mr. Smith.
Well, I think the logic of your submission is that, putting aside cases of allegations of personal bias or something like that, you never need to know the identity of a civil servant. Why should it? Why should it make any difference whether it's senior or junior? The senior civil service, I think, is 2% of the total, isn't it? It's about 10,000 out of 500,000, roughly.
Oh yes,
Right.
if there's a ministerial decision maker, that name will be known.
Yes.
And I'm not quibbling with the logic.
And why does it make any difference whether the civil servant is a decision maker or not? take the absolutely standard letter in a immigration case. Dear so-and-so, your application for leave to remain has been refused. Your case hasn't been seen by the Secretary of State personally. Yours faithfully, it could just be signed, yours faithfully, Squiggle, on behalf of the Secretary of State for the Home Department. And why does it matter?
My Lord, it may well not do.
Yes, well, that looks as though that's the direction of travel which your clients are seeking to take.
My Lord, no, we're not seeking to take that, and we've never sought to take that line. That is the logic of the principle. But as you know, the government position has never been to insist upon the removal of senior civil servants' names. They have particular concerns, which we'll come to no doubt, about the revelation of junior civil servants' names. They do not have those concerns about senior civil servants' names. So I'm not quibbling with my Lord on the logic of it, but that is not, as you put it, the direction of practical travel.
All right, well, we'll let you go on. We were on...
We were on the first of the reasons why the judge was wrong to say it renders it unintelligible. The second of the points that the judge makes, of three, the second of the points of three, is that the appearance, as he put it, created by the Secretary of State's approach is a matter of genuine concern. And we submit that that cannot be right. The premise for redaction is that the names are irrelevant to the issues. The redaction is on that basis, and it is well understood and long established that irrelevant material does not have to be disclosed and does not have to be provided as part of the information provided under the duty of candour. A reasonable person against whom appearance is to be judged would well understand that simple position. It's no more concerning than any other redaction on irrelevance grounds. And also they would understand that if they were relevant, then the names would not be redacted. So the appearance is not a matter of genuine concern or any concern. Thirdly, the judge concluded at paragraph 17, as he put it, that the purpose of the duty of candour obligation, cards face up, would be impaired. And our response is it would not. The duty of candour is limited by relevance.
Forgive me, which paragraph here?
17, my Lord, 17.
Back to 17.
And the reason it would not be impaired is because the duty of candour is limited by relevance to possible, or pleaded or asserted, grounds for saying the decision is unlawful in public law. Its core features, that's of the duty of candour, as I've explained, require full and fair explanation of any facts that bear on those grounds. It is not a doctrine that requires explanation of every feature of the decision-making, even if not relevant to those issues, nor one that requires the identification of all of those involved in the consideration of a decision. So that's the fourth submission, I'm afraid, with a few parts to it. The fifth submission.
Did you disclose all the information, all these emails that we've disclosed? Why you disclosed all the emails that have been disclosed, the ones we've seen, lots of which just seem to say, hi, I've got this email, I'm going to read it soon. I mean,
Well, my Lord, I'm afraid I can't offer much on that. I'll come to you.
They disclose more than they need to, that's up to them, and if they do, but if they pull the line up and say, well, we're going to send you all the emails saying we've looked at all these things, but we're not going to give you the names, you say, because your submission is the test as relevance, that's it.
Yeah, I do.
Right.
I do. It can't matter that they've over-disclosed if that's what they've done. I'm afraid I wasn't involved in the intricate disclosure process in these proceedings, but if they've over-disclosed, so be it. That doesn't answer or assist.
I'm wondering what issue they went to, because you say they were doing provided the information voluntarily if they went to an issue in the claim. And I just trying to work out
which one they went to.
They went to.
I'm not sure, I'm afraid, but we know what the issues in the claim were. So my fifth submission is that the names of junior civil servants will generally be, as Mrs. Justice O'Farrell put it, irrelevant. They were in this case, and there is nothing in the duty of candour that precludes their redaction on that basis. And indeed the judge, as we understand it, positively accepted, and he was right to do so, that the names were irrelevant on that basis, if relevance is tested as it should be by reference to the issues. As he put it again in paragraph 17, the outcome of the grounds will not depend on the identity of the decision maker or any other person involved in the decision making process. And we've set out in our skeleton at paragraph 20, we'll take up time on it now, the facts that make that clear. Taken by ministers personally, and you see the description of the issues as I understand them in the case at 20 sub 2. We've already discussed there may be specific situations in which the names of a civil servant, even a junior civil servant, might be relevant. Allegations of bias, whether the decision was taken at an appropriate level of seniority and so on. And we've already discussed the position that the logic of the submission might permit redaction of the names of all civil servants and not just JCS. But the answer to that is if the names are relevant, they would have to be disclosed. It's only if they're irrelevant that that possibility arises. And to the extent that it does, it's justified on that basis. But in practical terms, as I've said, and no doubt for reasons based in the concern to protect junior civil servants, that is not the practical route of travel, because there is a distinction that's drawn between senior and junior civil servants. Submission 6 is short and to some extent something of a tangent. It is that there is no principle that precludes the redaction of a part of a document or a section of a document unless it is both irrelevant and confidential. My submission is that irrelevance is a sufficient basis for redaction on authority and in principle, without more. It may well be, we've to some extent just been touching on this, but it may well be that often redaction will not in fact or in practice be made if there is no concern about leaving the thing in the document. But that's a matter of choice by the owner of the document and not a requirement of principle. That there is no good reason, I respectfully submit, for the introduction of any additional requirement of confidentiality. The obligation to disclose is and is properly bounded by relevance alone. And I only raise this because the administrative court guide might be thought to suggest cumulative requirements of irrelevance and confidentiality before redaction can take place, and that we respectfully submit can't be right. The relevant passage is at page 1363 in the final tab of the authorities. They're not the right reading of it. You see 15.5.1 is the bit that's of some concern. May be redacted as parts are confidential and irrelevant. And I respectfully submit that that does not correctly represent the law. I mean, I wish to unduly to criticise the authors of that document, but it's as well to be clear if you're seized of the issues. So that's the short point in relation to that. The seventh and final submission on relevance is to do with open justice. which you saw Mrs. Justice O'Farrell take as a starting point. But you also saw the conclusion that she reached, I think it was at paragraph 266 of the second decision in relation to that. Open justice doesn't sound if the material question is relevant. And that really is my answer to that. There is no derogation from this principle by permitting or not imposing an obligation not to redact on grounds of irrelevance. Open justice does not require any litigant, including the government, performing its duty of candour properly in judicial reviews, to disclose information that is irrelevant, still less the content of documents that are not necessary to the fair and just determination of the grounds of unlawfulness that are actually an issue. Moreover, there is no aspect, we submit, of open justice that demands that if only government is sued in a judicial review, or perhaps threatened with suit of that description, the identity of all of those involved in decision-making must be revealed. Government decision-making, of course, and almost by definition, affects, and sometimes affects deeply, those who are subject to its decisions. There's no right to demand the names of all such decision-makers. What judicial review does require is compliance with the duty of candour, which imposes onerous obligations, positive, proactive obligations on public authorities to provide the court with a full, fair and proper explanation of facts that are relevant to the determination of the issues which it is the function of the court to determine. But they are, as all the myriad of authorities I took you to at the outset indicate, bounded by relevance to the issues the court has to determine. So even if the starting point is that all documents in evidence should be capable of being seen in all of their forms, there are now well-established principles hammered out in both judicial review cases and in ordinary civil litigation that determine and shape in principle what the exceptions to that permissibly are. Those are the 7 submissions in relation to relevance. I wanted to make a couple of points, if I may, in relation to procedure, because those are of obvious and considerable practical concern to those who have the run and carriage of judicial review proceedings on behalf of the government. On redactions generally, there are, as we've seen, a number of different bases for redaction that are and have always been very common in judicial reviews. They include, perhaps as the most common, redactions on irrelevance grounds and redactions on LPP grounds. Ministerial submissions often contain legal advice which is properly the subject of redaction. My submission is that it is not necessary as a matter of process, and indeed it would be very burdensome indeed, expensive and entirely unnecessary, to require a witness statement in any case in which there is a redaction justifying each and every redaction. No doubt it is good practice to identify, if there's any doubt about it, and there may not be, but to identify the basis of the redaction, for example, by marking next to the redaction irrelevant or LPP or whatever it may be, which is tradition and has for some time traditionally been done, as the basis. And then if there's a genuine issue raised about it, how can that really be LPP from the context? It doesn't look like LPP. How is that really relevant because it sits within the middle of a paragraph and so it has to be relevant, all that. If there's a genuine issue about it, then it's permissible, of course, for the matter to be raised by a claimant and the point can be dealt with in the usual way, by application, which may or may not require a witness statement to be provided. But a routine witness statement, lest anyone thinks that that is the appropriate approach, is not, we respectfully submit, the default position procedurally. That's redactions generally. But secondly, junior civil servants, if the argument on relevance is accepted, then it will be relatively, if not highly unusual, as a situation in which the names of junior civil servants might be relevant to the issues in a judicial review. And again, my submission in procedural terms is that it is enough for GLD or whoever has carriage of the litigation simply to indicate, a bit like LPP or irrelevance, the basis on which the redaction occurs by identifying that that's the basis for the redaction of the names in the emails. And again, if the claimant wishes, as I indicated, to raise an issue about that, to assert that it's relevant for a particular reason or whatever it may be, or indeed to assert and suggest that there's a good reason for putting in ciphering or describing the units to make the document more intelligible, then of course that can be done. And there will then be a discussion, no doubt sensibly, between the parties in correspondence, and the court can rule on that. But again,
the redaction you contend for is that you won't know that ciphering would not be applied as a matter of routine. So you won't know whether the sender of the email of the 28th of January and the sender of the email of the 4th of February are the same person. You won't know what department they come from. You won't know what their rank is.
you may know which department they come from, because certainly if these documents are an example, the tailpiece of the email chain at least sometimes indicates that they're a dot levelling up or they're a dot home office or whatever it may be. But ordinarily, no. As I said earlier, that doesn't, in my submission, it doesn't matter for the purpose of the point of principle, which is about whether or not the name Smith needs to be included, because ciphering is always a possibility. All I'm doing in this procedural submission is to seek to identify a sensible, efficient way of taking that forward, so that if there is a reason for needing to know that recipient A is the same as the sender B, then that can be asked for.
All you're going to do is blank it out and you'll say name. You don't actually have to say name of junior civil servant, because on your analysis the same logic applies to civil servant service and disgrace in favour for you to give that. So all you need to do is say name.
We will say name, and that will junior civil,
really.
or it'll be junior civil servant name, because there is no practice, as I indicated, of taking out senior civil servants. I accept there's a question of the principle and the logical extension and all of that, but in practice you will never get there, because they don't do that. What they do is to take out the names of the junior civil servants. You'd say JCS or junior civil servants. But then, as I say, to test the point of principle, which is, does the name need to go into the public domain, which is the thing that they're worrying about, if it's appropriate to cipher, or you think that more ciphering needs to be done, then that's a matter for you. That doesn't touch the issue of principle, I submit. But it is there as a practical thing, and in ordinary cases, the documents will be perfectly intelligible without ciphering, which of course can be a burdensome task if you've got 14 people, 14 junior civil servants who might have been involved in an email chain, and then you've seen the extent of the redactions. The ciphering can be a time-consuming and expensive task, and there may be no need to do that. So it's just a question of trying to get the practicalities of that right. So those are the procedural submissions, just a couple of procedural submissions. Can I turn briefly then to good reasons for redaction? My short submission is that Mrs. Justice O'Farrell was correct in GLP, both in her interlocutory judgment and in her final judgment. There are legitimate concerns in relation to civil servants' names, junior civil servants' names. And if I may, I'm going to approach it on the basis that there is, as it were, a public interest on the side of disclosure, and there's a public interest against disclosure. The public interest for disclosure of the civil servants' names, if you are at this point, is of some importance. it is that premise is that the name of the junior civil servant is not relevant to the determination of the issues, because if it was, it would have to be disclosed anyway. So the premise for the argument about the public interest in disclosure is simply that it makes the document, to some extent, easier to read, because you can identify who things were sent from and to in terms of the actual names. But a little care with that, because, as I indicated, if it is appropriate or interesting to know that on the facts of a particular case having regard to the grounds of unlawfulness that are in issue, ciphers can show you whether the recipient of one document is the same as the recipient of another. And it is, of course, possible equally to produce departmental descriptions if that isn't evident, and which units within departments are handling things or are recipients. And that is important, I respectfully submit, because the starting point is irrelevance to the issues. And of course, that would be highly significant if one were analysing this as in a PII context, because the starting point on PII is whether or not relevance is established. And on this, the premise is that relevance in that sense is simply not established on any view. So it's only the additional ease of reading, intelligibility, in inverted commas, matters that are being thrown into the scales at this stage. And of course, once that is recognised, it's clear that this context is not remotely comparable to what might be thought to be an obvious and real significance in terms of the public interest in the disclosure of, for example, the name of a murderer who might be suing the parole board. And it's also important to bear in mind, because no doubt we will hear lots about open justice from Mr. Vassal-Adams and perhaps also from my own friend Mr. Binsky. But open justice for present purposes is open justice in the sense of the provision of information which is not needed or relevant for the purpose of determining the issues, but is simply a document that might assist a court or a litigant more readily to read or to understand a particular set of email chains. The public interest against disclosure is really what underpins the reason we're having this debate. And I don't want to undersell it, because there is genuine and real concern on this side of the court and those who instruct us about the idea that junior civil servants' names are routinely, and even if not relevant to the determination of the issues, to be put into the public domain. Those concerns we submit are real and important, and they are sufficient, is my submission, to permit redaction with ciphering as appropriate, as I've indicated, as the general approach. And they are sufficient, particularly because obviously that brings in a relative analysis, particularly when one understands the true weight, brackets, at the most slight, in securing the additional intelligibility that the actual name Smith would bring when reading, for example, email chains. The concerns were and have been summarised in particular in two witness statements. I think one for these proceedings and one not. But the two witness statements of concern are those of Joanna Key. I'm just going to give you the references given the timing, or I'm going to run out of time. Joanna Key, call bundle, page 89. And Jonathan Maron, which was the witness statement supporting the application in the GLP, the Good Law Project case that Mrs. Justice O'Farrell decided. So Jonathan Marin, in that case, we've given you that statement from that litigation and brought it over to rely upon it here, as it were, because it was the same set of issues, essentially. And that may provide something of the answer to my Lord Justice Mell's point about whether or not they were exactly the same junior civil servants. That was a statement produced in that case. You'll see the justification for it. That's core bundle, page 43, in the core bundle that you have. And in summary...
Could I just ask you about
yes,
one
my Lord of Court.
thing said by Ms. Key in her statement? She says that junior civil servants, that's the 98%, do not fulfil decision-making roles. Is that right? Is every letter sent to, say, an applicant for leave to remain in an immigration case is written by a senior civil servant, surely?
Well, in immigration, it might be written by an immigration officer who's a statutory office holder.
No, but the ones sent for and on behalf of the Secretary of State for the Home Department are surely relatively junior officials. And even in other departments.
Well, my Lord, I don't know.
We have no cross-examination in judicial review, but it seemed a very surprising assertion to me that only the top 2% of civil servants take any decisions about anything.
Well, that's the evidence. I don't know how it breaks down in immigration. I don't know whether they're drawing a distinction between immigration officers or civil servants, but the basic and short point is that it's if you're a junior civil servant, you tend to operate, or you do operate, under the direction and subject to the control of those above you who are senior civil servants. That's certainly the position by the time you get to ministerial submissions, which is really what you're considering in this particular case, because the decisions were made by ministers personally.
Yes, of course.
But that's the evidence. I understand my Lord's question. I don't know the answer.
You wouldn't be here if we were talking about just this particular case.
No.
This is.
Yes, no, I don't seek to
Yeah.
to duck the question, as it were, but I just don't know to what extent. I'm assuming that's accurate. There hasn't been any suggestion not.
All right.
Well, the three particular concerns that emerge from those statements, I'm sure you've read them, so you don't need me to go back through them, but the concerns are perhaps in three groups. One, welfare concern / duty of care. There are concerns about involvement in controversial aspects of social policy, leading to social media comment and so on. The risk of that sort of difficulty is enough, I submit, but it's clear that there have been instances of that sort of difficulty arising. See for that purpose Miss Key, paragraphs 12 and 13, and Mr. Smith, who is at page 86 of the core bundle, at paragraphs 8 to 9. Are these all supplementary? I'm so sorry, I've given you the duff references. I'm very grateful to my friend Mr. Bassett-Adams. Have you got the statement? You've got the statements?
Yes.
And the supplemental?
Yes.
Thank you. Apologies. There are then general worries still under this heading about the name of the junior civil servant being linked to litigation involving claimants who might, for a whole variety of different reasons, provoke strong sympathy and strong feelings amongst all sections of the public. The junior civil servants are themselves doing pressurised jobs and, of course, cannot and don't protect themselves, and those responsibilities to safeguard their well-being, and it's not just safeguarding their well-being, it's ensuring they're in a good place to do the best job they can. Those concerns are unsurprisingly taken extremely seriously at the top of government and of the civil servants and of the civil service, and those are well recognised features, I submit, of government. The second is that it encourages participation active participation, strong and full debate with junior civil servants pitching in as appropriate to the process of decision making. That's Ms. Key at paragraph 15. That's all against the backdrop where they are less likely, at the very least, whatever the stats turn out to be the actual decision maker. Normally that is someone else, whether it's actually the minister, as in this case, or senior civil servants, may not matter. And thirdly, there is consistent past practice leading to some expectation, as it were, of privacy, and that is dealt with in Ms. Key's statement at paragraph 10 and was one of the matters specifically alighted upon by Mrs. Justice O'Farrell in her decision making in the second of the substantive judgment she gave after the trial in.
How can that expectation of privacy have grown up in the light of the guidance, which I see dates from 2010 and is on page 79, which makes clear that redaction is not the norm and arises only when dealing with matters such as LPP, PII, national security, international relations, or other similar concerns?
Well, my lord, I think the reference to the consistent practice is to the consistent practice of taking out junior civil servants' names, and that has been the consistent practice in litigation. That guidance is not designed to exclude redactions on irrelevance grounds, and is not designed to cover all situations. And there's no earthly reason why consistently with that practice, junior civil servants' names could not routinely be redacted, obviously, unless they are or may be relevant to the issues in the case.
When she refers to paragraph 10 to disclosing official documents, is there some magic to the phrase official documents? Is she thinking of ministerial submissions, or do we just not know what she means by official documents?
Paragraph 10.
Yeah, at page 90. It says the practice is when disclosing official documents.
I'm not sure there's any magic to that. It simply means documents in which the department generates.
Any document from the department to their department.
I don't understand that to be a magic phrase or a phrase which limits the particular. Some emails would be official and some wouldn't. If you're doing the business, you're official, is my understanding.
Does the 2010 guidance is what we have in the bundle, and I assume somebody would have told us by now if there was a new edition. Does it say anything about the redaction of names?
So that's in the authorities bundle.
It's in the supplementary bundle. The paragraph about redaction is
Could you, Michael, sorry, could you give me the page number?
page 79,
Yeah.
paragraph 4.3.
Yeah. Sorry, I have the passage. Yeah.
Yes.
I mean, the question is there I don't know whether there is a more up-to-date version now. I've certainly seen, without revealing privileged information, what is potentially an update, but whether that's become published or not, I'm not sure. But this is what we've got for the moment.
Does anybody in court know whether there has been a new edition published?
No, it hasn't, as I understand it.
Thank you very much.
So this is what you've got.
Yes.
I will Lord, nothing there. If the question is, does anything there refer to junior civil servants' names, the answer is no. If the question is, does that purport to be exhaustive, as it were, so that it's only LPP, PIR, national security or international relations, then the answer is no, because in the second sentence it's matters such as, and irrelevance is an obvious ground. So even though it doesn't refer to junior civil servants' names, it equally doesn't refer a thing to irrelevance as a ground, even though it's longer than recognised.
Yeah, it does actually.
I say sorry, 4.3, but yeah, 3 lines up from it does.
Or because it is irrelevant but sensitive, but it's the sensitivity that seems to have attracted the non-redaction principle rather than the word irrelevant, unless I've misread it.
Well, it's irrelevant but sensitive, and we're back into the submission I made about
Yeah.
confidential and irrelevant.
Yeah, the process of redaction is a process to extract material. The department is not prepared to disclose because it's irrelevant but sensitive. It seems to be because it's sensitive that they don't want to disclose it. Like the public procurement on the masks and the PPE clothes in the Farrow judgment.
Yes, but my Lord, my submission, one needs to be a bit careful with government guidance of this kind, which is designed to provide assistance, broad assistance to those who are operating the system. If this was incredibly favourable to me and showed junior civil servants' names, grounds of irrelevance, and repeated my submissions to you, it would still be a matter for you to make a judgment about what the right approach in principle is. And I respectfully submit that it isn't a proper reading of this to say you can't just establish irrelevance, you've got also to establish sensitivity. It may be that in practice, and that's the reason why we don't redact civil servants' names who are senior but do for junior, because they're concerned about the one but not the other. But it isn't a legal preclusion. It doesn't prevent, if this is the purpose of the question, it doesn't prevent an expectation of privacy having arisen, if that is the practice that has been followed, and the evidence before you is that that's precisely the practice that's been followed. Well, of course, the core and fundamental point in all of this is the one that I've already made, which is ultimately, if you get to this stage, whatever the test may be, however you characterise it, one would be considering an exercise in which the public interest in disclosure and the public interest against disclosure are being thrown into the scales, and the short and central submission is that there is very lightweight, if any, on the side of the scales that says you need to disclose the junior civil servants' names, precisely because the premise is that they are irrelevant to the issues and there's only the broad intelligibility, in inverted commas, justification for that. And I've made my submissions about that, the lightness of that in any event. As against that, there are real and genuine concerns of the kind set out in the evidence, and those are more than sufficient, I respectfully submit, to tilt the balance. And my submission is, as I say, that they do have a reasonable expectation of privacy. And of course, it isn't just the name in isolation, it's the individual's identification of holding that role in the context of the matters that are the subject of the litigation, which may well be controversial. And I did want to take you briefly to the Cox decision, which is the one in the upper tribunal that I referred you to. That's behind tab 27 in Authority Bundle 2. And 801, you'll see the paragraph 2 under the reasons for decision. So you'll see the particular context in which the issue is arising, and no doubt there are special features of that context that are important for the purpose of the decision.
Sorry, Sir James, which paragraph?
Paragraph 2, my lord, on page 801.
Oh, yes.
I'm just trying to give you the flavour and the
Yes.
background. If you ever just cast your eye down, paras 2 and 4, if you would, you'll see the names referred to in paragraph 4, final line.
And in 5 again, do we know, it says a joint delegation of senior Home Office and Foreign Office officials. Do we know if they were senior service or whether they would be junior civil servants on this? Or do we just not
Not
know?
sure we do, it's just pure names, as it were. But the issues you see that arose there was under section, in particular under section 40 sub 2, which drags in all the data protection legislation into FOIA.
James, can you show paragraphs 23 and 46?
23.
23.
And 46, my
Well,
lord.
well, let's go through it. We might go through it in a slightly more logical way, if we may. Can I invite you to look at 16 first of all? Do you see the legal structure within which the issues are arising? You might want to pick up what then become referred to later on as the Goldsmith questions in paragraph 20 and 21. Again, as part of the legal framework for the actual decision making in this case.
I'm afraid Goldsmith questions is.
Yeah.
I don't know what they are, let alone what the answers are. But
No, but I think the
maybe
Goldsmith,
I
that's
don't
why I
read-
go there. So Goldsmith's questions are the ones that appears referred to in paragraph 20. If you read 20 and 21. And 23, if you would. And then 24 for the Information Commissioner's notice. So in essence, the reasoning was, didn't necessarily have a reasonable expectation of privacy, but did have a case that it wasn't necessary to disclose. And then you'll see the disposition of the relevant issue starting at paragraph 32. You'll see by reference to the Commissioner's guidance, para 34, and what is said there about junior and senior staff. The "it all depends" conclusion in the context of the issues they were considering at 35. Their acceptance of the first-tier tribunal's reasoning in Home Office and Information Commissioner in 36. See in particular the final sentence in the quote in that paragraph, if you would. then in particular the reasoning at paragraph 46, bottom of page 811, and over onto 812, which is the sideline passage. You could read that. Of course, these are issues that are decided in the particular context of FOIA and the data protection principles that FOIA drags in. But it is of some interest, at least, because they are considering the divide between senior and junior. They are considering and concluding that there is considerably less justification or need for the public to know the identity of an individual who is at the junior level, in particular if he does no more than communicate basic policy detail, as opposed to being the person who takes responsibility for the various decisions, and that is of some real interest to the justifications advanced in our context. And so we do respectfully submit that that is helpful in that respect. And although, of course, the answer to the question that they give in the FOIA context is ultimately it all depends, which the judge came back to as a principle on a couple of occasions, we can perfectly contentedly live with that here, because it all depends simply throws one in our context back onto the question as to whether or not the material in question, namely the names of junior civil servants, is actually relevant to the determination of any of the issues in the judicial review. And the premise for this set of arguments is that it isn't, and the only thing you have to throw into the pot against the protective elements that the upper tribunal accepted in Cox is the increased ease of reading of the documents, and that, my respectful submission, is not sufficient to outweigh the concerns that are contained in the evidence. In other words, those are my submissions in opening.
Thank you very much, Sir James. I think we'll break off at that point, Mr. Binsky, and resume at 10 to 2.